attorney Kathleen Zellner, who's filed post-conviction motions, raising newly discovered evidence, ineffective assistance of counsel, and what's called Brady violations, where the state was in possession of information that could have pointed towards Stephen's innocence, and they withheld that from the defense and the court. She lost in her first round in the trial court with really kind of a ridiculous 6-page decision. She filed a 200-page motion, and the judge dismissed even without hearing and without even hearing from the state. The state never even responded,
Yes.
but the court denied the motion. To give you an idea how ridiculous that kind of treatment of this, the case of this seriousness is, the trial judge in our case, who then heard the first round of appeals for Stephen Avery, Judge Willis, on his first post-conviction motion, he denied it as well, but he wrote a 100-page decision dealing with all the issues. Much more thoughtfully, I still think incorrectly, but at least with a little more forethought. So that is now, Stephen's case is now back in the Court of Appeals. The real primary issue is he entitled to have a hearing where Kathleen Zeller can present some of the evidence that she's got obtained recently, and then I think her brief is due the end of this month. All right. What about Michael Peterson? What's going on with him?
Michael's case is over, thankfully. We'll talk more about the Alford plea at some point later on. I know we've had a few questions about that. He is living in Durham, North Carolina, which is not where I would choose to live if I were him. He's living in a ground floor apartment with no steps. Twice is enough. He's existing on a military pension, on what's called Social Security, which is our state pension in the United States. He writes about his prison experiences. Not sure he'll ever publish anything about that, but he's a writer, and so that's what he does. And just goes to the gym, goes to the grocery store, does all the things that everyday people do. Is very thankful that he's no longer an inmate in a prison in North Carolina, and visits his children and grandchildren on a regular basis. So he's living a pretty mundane but happy life. So let's go to the elephant in the room, because we had a lot of questions about making murder to, for example, why did Stephen Avery swap defense attorneys to Kathleen Zeller, for example, and then a follow-up on sort of what's your impression of the arguments that Kathleen Zeller has been making, in making murder to.
Okay, so first, Stephen didn't actually swap attorneys to get Kathleen Zellner. He was without counsel for a number of years. Some people wondered why Dean Spang and I didn't keep his case on appeal. Did we, was it because he ran out of money? Did we just dump him, or why didn't we stick with him? And it really has nothing to do with that. It's a bit of a quirk in the law in my state, Wisconsin, that if you're going to raise any kind of ground of a possible mistake by your trial attorney, ineffective assistance of counsel is the actual phrase, you have to do that in your direct appeal at the very beginning, which is why you saw Judge Willis, the same trial judge, also hearing post-conviction motions, because you have to file a number of motions in the trial court before you ever can go up to the next level Court of Appeals. And so, because you need a fresh set of eyes, if the trial attorney missed something first time around, and it can certainly happen, it's unlikely that the same attorney would catch the mistake on the appeal. So you almost always change and get new attorneys on your direct appeal, and that's what happened in Stephen's case. But then after his,
Who represented him on the direct appeal?
he had the state appellate public defender representing him, two very seasoned, very good lawyers, staff attorneys, not hourly paid attorneys like Lynn Kuczynski, who represented Brenda Dassey at the beginning of the case. They did a good job.
What issue did they raise?
They had a number of issues, including we had challenged the multiple searches. They basically locked down the Avery auto salvage yard for 8 days. They only had one search warrant until the very, very end. And one of the arguments we raised was that was an illegal search, that when they finished searching Stephen's house or the trailer the very first night, they were done. For them to re-enter, they should have gotten another search warrant. That was one of the issues. There was an issue with the jurors, the Denny issue, the third party suspect that we wanted to point the finger at. They raised that issue as well. And a number of others, like I said, were pretty extensive. So then after his direct appeal is done, though, in the United States, you're not entitled to have an attorney appointed to represent you if you can't afford one beyond your first appeal. And so he didn't have an attorney for years until he asked Kathleen Zellner about 2 years before Making a Murder came out, and she rejected him initially. Then once the documentary came out, she reconsidered and agreed to take his case on pro bono. So that's why he ended up with Kathleen Zellner.
And obviously she's been critical of some of the stuff that you and Jerry either did or didn't do. For example, she's claimed that you didn't point the finger at other people, which what I'm hearing you say is that was actually an issue that you did raise on direct appeal.
We did actually raise that on direct appeal. We named a number of suspects, including the ones that she's now naming, Bobby Dassey and Scott Tonic. But the judge denied us the opportunity to do that because he argued we didn't show that any of those people had a motive, which the irony in that is that in a criminal case, the state never has to prove motive of the defendant. And yet somehow a defendant must show motive before he can tell the jury that somebody else might be the killer or the perpetrator of whatever crime it is. It's a real double standard in the law. It's a rule of evidence that almost all the states have something like that. And in this particular case, they expanded it in a way that really prejudiced Avery much more than prior cases. So that's one of the grounds. She's also raised several grounds of ineffective assistance of counsel, either that Dean and I should have done this or should have done that. Eventually there will be, I think, a hearing. The Court of Appeals, I think, will send it back for a hearing. At that hearing, Dean and I both will have to testify about why we did or didn't do something. And, if we made mistakes, we'll certainly answer them truthfully, those questions, and admit that, because that's part of her job as a post-conviction attorney. She needs to do that. I do about half appeals. We have to do that as well. The reality is that this is a human endeavor, and people can miss things, even when you're trying the best you can, because you're in the heat of the battle as the trial is beginning, a condensed period of time, you've got to get ready. And but I can't speak in great detail about the specific decisions we made or didn't, whether to use a particular expert, for instance. Someone asked a question about that. I can't answer those kinds of questions specifically now, because I will almost certainly, I think, be answering it in court, and I certainly don't want to help the state give them a preview of what those answers would be ahead of time, and wouldn't be in Mr. Avery's interest as well.
I think one of the things that folks may not recognize is the difference between being a trial lawyer and being a post-conviction lawyer. And so let me just talk about that a little bit, because Jerry is somewhat limited in how specific he can get since these issues are still pending. But I've done both. I've been a trial lawyer my whole life. I've also done post-conviction work. And the difference is when you're a trial lawyer, things are coming at you sort of fast and furious. You don't necessarily know what the prosecution is going to do. For example, in the staircase, we kept trying to get the prosecutor to say whether he was going to get into the Germany stuff or not, and he wouldn't even tell us. And then the judge wouldn't rule on whether it was admissible or not. So, we're sort of sitting there not knowing exactly what evidence is going to come in. That's not uncommon at all. Whereas if you're doing post-conviction work, which is what Ms. Zellner is doing, she's got the whole transcript. I don't know how many pages your transcript was, but I'm assuming it was thousands. So basically, when I'm sitting there with a post-conviction case, I've got what every single witness has said. I've got what every argument the DA has made sitting there right in front of me. There's no guesswork. And so what I'm doing, and I think what she's doing, is trying to poke holes. And you don't necessarily need a consistent theory when you're doing that, because judges understand that you can say, well, this person did it, but if that person didn't do it, this other person did it. And you can point to 2 or 3 or 4 potential suspects. You can't really do that as a trial lawyer because you don't have any credibility. You've got to pick one and pick your best one and go for it, because juries are not going to be terribly impressed if what you're saying, well, we think Bobby Dassey did it, but if you don't agree with that, then it's really, her old boyfriend. And if you don't really believe that, then, maybe it's this guy she met on the road. It just doesn't have any credibility. So it's a really, really different process. And I, from my perspective, and I've known Jerry a long time. I don't know Dean at all. But it strikes me, at least, as a little bit unfair. I've made ineffective assistance claims. I will just tell you that there is no way on God's green earth that this ineffective assistance claim will ever succeed. All right? It is, in my judgment, a frivolous claim, because they did everything that a trial lawyer could possibly do. That's not to say they didn't make mistakes. I don't know what mistakes they made, but that's not the issue. When you're alleging ineffective assistance, you have to allege that the person fell below the minimally competent standards of defense lawyers. No one's entitled to a perfect trial. They're entitled to a fair trial. So, from my perspective at least, if you want to attack Ken Kratz, go at it.
Yeah, I want.
If you want to attack the police and how they conduct their investigation, go at it. You want to attack the Brady violations, the fact that computer stuff wasn't turned over to these guys so that they could use that to point the finger at Bobby Dassey. Those are all really valid claims. So my own personal feeling is that the ineffective assistance claim is really not terribly meritorious and not terribly fair. That's just my judgment.
But the reality here is that what matters is what gets Stephen Avery a new trial. And if it takes an ineffective assistance of counsel, I'm fine with that, because he did not get a fair trial, in my opinion, never got justice, and needs in some way or another to get that. I do think, without, I don't want to leave people with the impression that he's, by what you said, since if ineffective assistance doesn't work, he has no chance.
No. I think it's the weakest claim. I think there's some very strong claim. I think that Brady claim is really strong.
And statistically, that is the single biggest chance people have in getting a new trial is when it's been shown that the state withheld exculpatory evidence pointing to the defendant's innocence. And if in fact she gets a hearing on that and can establish all of that, then he still has a very good chance, I think.
And Jerry gets uncomfortable when I say too much about that, so I didn't mean to make you uncomfortable.
That's all right. That's okay. By the way, you said that we've known each other a long time. I don't know if people know the David was actually one of my very young clinical law professors at the University of North Carolina at Chapel Hill, and he actually helped teach me what it was like to be in court. We represented real clients, had to think on our feet, and all the basic skills that you later have to polish. David was my mentor, and so it's kind of ironic that we were both many years later involved in documentaries that became big hits, and so
little did we know.
yes. All right, here's a question about that. Why is the documentary filmed in such proximity to the crime? So did they know then that it would become such a controversial documentary?
Yeah, it's an interesting question, because little did I think in 2003 that I'd be sitting in Stockholm, Sweden, talking about the Peterson case to 400 people who I've never met before, who have watched me in court. So none of us had any idea where this was going to go. They were just interested in doing a documentary on the criminal justice system in the United States. And that's really what sort of led me to be willing to listen to them and to agree once we negotiated several things that, from my perspective, protected attorney-client communications. Because, oftentimes when people come to you and they want to do a film or a TV show about a case, it's all about, who did it, what happened, it's sensationalized, and they're really not interested in the process. They're interested in, the story, who's guilty, what happened. That wasn't their approach at all. They had done another documentary called Murder on a Sunday Morning, which, if you haven't seen it, is a really excellent true crime documentary. It involved a
Academy Award winning.
Yeah, they won the United States Academy Award for Best Documentary in 99 or 2000. And that documentary was about a poor black defendant who was represented by a public defender. And they finished that, and then they were looking for another case to study the American justice system, and they wanted something that involved someone who was not poor, who had the means to defend themselves. So they went looking for that case. So if you've heard that, we contacted them, or Michael hired them, or I, reached out to them, none of that's true. They found us. And it wasn't about whether this case was going to become famous. It was about a study of the criminal justice system, and that's what they focused on. And to this day, I don't think the filmmaker cares whether Michael Peterson is innocent or guilty. It's not the point of the film, and it's really not my point in being here to talk about you. We'll talk about various things as the evening goes on, but what I really like about it, and why I think it's been so successful, is because it provides an incredible window into how the criminal justice system in the United States works, and into what criminal defense lawyers actually do, as opposed to how social media or the general media portray what we do. And so that was sort of my motivation, and none of us had any idea that it was going to turn into this.
It's interesting, and that might be another, it's a link between these two documentaries. It might be one reason they're both so successful and popular is the filmmakers for Making a Murder, they were not Academy Award winning filmmakers at the time. They were graduate students in film from New York University, and they decided to do this documentary for the similar reason. They saw an article on the front page of the New York Times about this very unusual case of a gentleman in Wisconsin who had been wrongly convicted, spent 18 years in prison, was exonerated by DNA, and then gets out and 2 years later is charged with the murder of a 25-year-old photographer. And they thought, in that interim while he was out, there had been a number of reforms of the criminal justice system in Wisconsin. What went wrong that first time? Why was Avery wrongly convicted? And they thought, this would be a really interesting, almost social justice study to see how the system, quote unquote, reformed, applies to him now. Here he is finding himself back in the system. Has it gotten any better or not? And that was really their interest in coming there. When they came there, they did not know that there was going to be anything about conflict of interest with biased Manitowoc County Sheriff's Department investigators crawling all over the place, finding all of the property. At that point, the public was being told that they had stepped aside and that the case was being investigated by somebody else. Only after they got there and they discovered that, they discovered that all these other developments like the magic key that's found on the 7th entry of this residence that nobody else could see in plain view on the floor. And so the case just developed all these really interesting twists and turns that they had no idea ahead of time it would.
Well, and indeed, obviously in the staircase, it goes on for 15 years, and you can see Michael's age, you can see the impact that prison can have on somebody. I mean, it was really shocking to me when I saw him in 2011, because I hadn't seen him in a couple of years. We had been talking on the phone, and we had been corresponding, but I had moved and I hadn't seen him. And when I first saw him, it was a real shock, as I'm sure it was to some of you when you saw him in that documentary. So I think that, again, that's part of what makes this all so interesting, is that these cases are not, they're not over really quickly, and there's all these twists and turns that no one could anticipate, and no one did anticipate. So just to follow up on sort of where Kathleen Zellner is going and what you guys did, to what extent, this is another question we've had, to what extent did time or financial resources impact your ability to defend Stephen Avery? It was a question that was directed at both of us, but I don't really think that time or financial resources really impacted my ability to defend Michael. I was very fortunate in that case with regard to both of those things. Other things not so fortunate. Those two issues I was all right with. What about you?
Well, time was certainly a factor in our case. I mean, this was a huge, high-profile case when it was going on. We have a victim rights amendment, a constitutional amendment in Wisconsin that allows them to push a case quickly to resolution, even though it never really resolves. If there's mistakes or a wrongful conviction, they can go on, as we now know, for decades. But so we were definitely under a time crunch. When we got on the case was already 4 months old. It was being handled by a trial-level public defender, and then Stephen settled his criminal case for the paltry percentage that he got, what he hoped to get originally before he was charged, and then he used that to hire Dean and I and pay off the expenses from the civil case. So, it wasn't like in some cases where the judge says you're trying this in 90 days and that's it. You got no more time. There are judges that do that. But we had already had, I think the case was set at least twice and had been postponed by the time it finally went to trial. And so there was a very limited, we had 25,000 pages or more of discovery, police reports, computer printouts, cell phone records, all these things that's very time consuming to go through, and hundreds of hours of recordings. They recorded every single phone call or personal visit that Stephen Avery had with his family, or even they were recording his meetings with the pastor, as I recall. That became an issue. What if they shouldn't have been recording a cleric having a private conversation with him. But anyway, there was a lot of these issues going on, and so it was difficult to try and pull didn't know what the state's theory was. We didn't know if Brendan Dassey was going to be a state's witness against his uncle until 1 week before the trial. They kept stringing it out and stringing it out and stringing it out. And so we had to be prepared to attack that confession, false confession, as if Brendan might have come in and because of the pressure of the state to do a plea bargain, saying we'll go easier in your case if you testify against him. And so, you know, it was, I would say that more than anything else. The time was a bigger issue than the resources. We didn't have the resources we needed to really do it. When they came up with the FBI came up with this EPDA test at the last minute, you know, we asked around, we've been trying to find anybody to do that kind of test, and nobody in the country did it. And we were quoted something like $15,000 or $25,000 for someone to do it, because they would have to create the whole protocol in the first place. And we asked the judge for funding for that, he denied it. Said, we'll just wait for the FBI's test, which is gonna come in the middle of the trial. And we said, well, wait a minute, we don't have, you know, there's no time for us to do it then. How are we gonna have our own expert? He didn't care. So I think those kinds of time issues were probably the biggest difficulty we had.
Talking about Brendan's confession, I've got a short clip of that confession, and I thought it might be interesting. I know you've all seen it, or a lot of you have seen it, to replay it and just get your take on what's going on and why they're doing what they're doing, and talk a little bit about the read technique, which is the technique they're using in that particular thing. So let me just play that clip.
What else did you do? Or there was something else with them? So what else did you do? Come on. Something with the head. Brendan? What else did you do? Come on.
What he needs to do, Brendan, we know he made you do something else.
What was it? What was it?
We have the evidence, Brendan, we just need you to be honest with us. Then I need to call for a hearing.
What else?
What else was done to her head? Did he prostrate?
What else? What else?
He made you do something to her, didn't he? So you would feel better about not being the only person, right? Yeah. What do you make you do to her?
What did you do, Brendan? It's okay. What do we need to do?
Caught her.
Where?
On a throat.
What else happens to her in her head?
Extremely important you tell us this. For us to believe you.
Come on, Brendan. What else?
We know, we just need you to tell us. That's all we can remember.
Okay, I'm just gonna come up and ask you. Who shot her in the head?
You did. Why didn't you tell us that?
you know, I think most people who watch that clip come away feeling like this is just not a real confession, that it's forced and it's unreliable. But there are a couple of things going on from a technical perspective that might be interesting to just share. For example, you know, they keep saying things like, why did he make you do it? Or what did he make you do? What's that about?
So, all right, this is a clip that just really illustrates well, but illustrates only part of this Reed technique, named after a guy named John Reed, who in the 1940s came up with a really psychologically coercive technique of questioning, very confrontational, that's based on what's later proven to be sort of pop psychology myths, all disproved. One of which is that police officers are better lie detectors than anyone else, when in fact study after study has shown they're no better at detecting who's telling a lie than anyone else who's reasonably discerning. They also use these techniques like a false friend. So what they'll do is the detective will make a decision, aha, I think this guy's lying, he's guilty. And from that point on, it becomes an interrogation. An interrogation at which they're taught never accept a denial. Somebody counted up, you don't see it anywhere near the whole interrogation here, but somebody counted up Brendan Dassey denied something like 75 times in all of his confessions. They will not accept them. They're told that they can lie to the suspects. America is the only place in the English-speaking world where that's still permissible. They can say, we got your fingerprint on the gun, or we have your DNA, when they don't. And they're allowed to do that. They use what's known as the false friend approach, which for someone like Brendan, young people and vulnerable adults, is particularly pernicious because you don't see it in the documentary. And in fact, interestingly, Brendan's jurors never saw this part of his confession because the judge refused to allow it to be heard. The defense wanted to present this portion. And it's a portion where when they first start talking to him, they say, now look, Brendan, you know, there's people in the prosecutor's office that are saying, why isn't Brendan Dassey charged? You know, he was with Avery that night, he was at the bonfire with him, and he's obviously involved, he should be charged. But we're saying, no, we're holding them back because we think you're a good guy, and you can make it look however you want, because we know he's the one that put you up for it. And we know what happened. You just have to tell us. And they give this false, knowledge technique as well. And then they evolve into the hold back piece of interrogation, which is the one way you can really tell a false confession from a true confession is if there's a piece of provable known evidence that the public doesn't know, that only the real killer would know.
And the police.
Pardon?
And the police.
And the police, correct. And the police know it, but nobody else knows it, and so they test to see if the suspect will confirm that what they already know to be the fact. And in this case, it was the fact that she had been shot in the head. Just a day or two before this interrogation, they got an expert's report saying that there was a little double hole in a piece of skull fragment, and that she was therefore had been shot. And so that's why they're asking these questions. Tell us what you did, and then they start hinting, what happened to her head? Come on, we already know, but you got to tell us. And then he's going through these guesses where it's like, what do they want me to say? That's where you get the slit the throat.
Punched her in the
cut her hair, and even after slitting the throat, what else happened? What else happened to her head? They then strangle her, which is really strange, and then she's still breathing after all of this is going on. And so that's when he finally says, I don't know, I can't answer. And they get frustrated, and they just say, we're just going to come out and say, who shot her in the head?
And that's the holdback fact.
That's the holdback fact, which they blew by telling it to him So this technique has been successful in getting guilty people to confess, but also, unfortunately, it ensnares a lot of innocent people. And with all the DNA exonerations in America, they've done a lot of study of those cases and say, what went wrong? And they found that when juveniles are the suspects being interrogated, that 43% of them falsely confessed to committing the crime when the DNA later proved they didn't do it. And people were thinking, well, why? What's going on here? Why is this happening? And then you start looking more at these techniques that are used, and that's why everybody else has pretty much abandoned this technique, but America, law enforcement really refuses to do so.
So, if anyone ever tells you that they would never confess to something they didn't do, that's just not true. Because I will promise you that if you're isolated from everybody you know, and the police are telling you that they know what happened and they've got your DNA, and if you're in the United States, they're going to try you for your life and put you on death row and kill you unless you confess. But if you do confess, they'll let you plead to 5 years.
Particularly if you're a person of color or recent immigrant status, all of those things factor in.
So it's false confessions are a real problem, and I think that clip really demonstrates why they are.
Now, one little bit of hope. There has been some improvement because of Macon murder, and only because of Macon murder. 2 states, Illinois and California, have now outlawed police interrogation of juveniles 15 and under, I think it is, for serious cases, without an attorney present. And the attorney can't be waived, simply cannot be waived. So, and the second largest trainer of police in the United States has announced that they will no longer teach this technique because they think it has a high incidence of false confessions.
Anyway, I just thought it would be interesting for you to hear some of the reasons why this technique is used and how it's used.
Okay, here's a question for you. It's an easy one. As a defense attorney, is it important that you think your client is innocent?
Actually, what's really important to me is to find out the truth about whether the client is innocent or guilty, or whether the client has done what he's charged with or not, or more accurately, what the true facts are. There's this sort of myth that defense lawyers don't want to know, if your client has committed the crime, you don't want to hear it, you just want to operate in the dark about that, and nothing could be further from the truth. And the reason for that is that if you think about it, if you're a doctor and a patient comes in, and the patient doesn't tell you where the pain really is, you're not going to be very successful in diagnosing what the problem is or helping that patient. And the same thing is exactly true when you're talking about a lawyer in a criminal case, or really in any case. So if I'm going to do my job and help this person, and people talk about how can you defend these people? How can you defend someone who's guilty? The reality is that the way I view it is I'm helping somebody who's in a really bad situation. And to help that person effectively, I need to know the truth. Now, I don't expect the truth to come out right away, because I've got to build a relationship of trust with that person. Especially if they've done something really bad, they don't want to tell me that, generally speaking, right out of the gate. They're worried that I'm going to judge them. They're worried that if they tell me the truth, I may say I don't want to represent you. So I assume that my clients are holding back certain things when I first meet them, and I don't judge them for that, because I think I'd probably do the same thing if I were in their shoes. And so I try very hard to build a relationship with them where they understand that I really care about what happens to them, that I'm not going to be judgmental about whatever it is they did, and that I really need, and I tell them this, that I really need to understand what happened if I'm going to be able to do my job properly. And that's the reality. Now, if they tell me that, yes, I did it, my focus is going to shift. You know, it's probably not going to be on how can we prepare a defense at trial. The focus is probably going to be on what can we say to a prosecutor to convince that prosecutor to perhaps drop the charges down to something that's more reasonable. And I know you don't have plea bargaining here in Sweden, but we certainly do in the United States. And it's a major part of our system, and it's a major part of what criminal defense lawyers do. You know, something like 95% of cases are disposed of through plea bargains. And so, you know, if somebody comes in and they tell me they did something, the first thing I want to know is tell me the circumstances. Give me the context, and help me understand your background and where you were coming from and what you were thinking and why you did it, so that I can then take all that information and communicate it to a prosecutor in a way that perhaps convinces the prosecutor to plea bargain the case to something less serious. Moreover, no matter what the prosecutor does, I may have to go in front of a judge and try to argue about what the sentence should be, what the punishment should be. And again, I need to know all those other facts to be able to put what this client has done into context, because the vast majority of time, we're not dealing with evil people. You know, we're dealing with people who made a really bad mistake, oftentimes under enormously adverse circumstances, where if those circumstances hadn't existed, they would have never done what they did. And so our job really is to make that clear to the judge. So yes, I represent people who have done what they're charged with, but I do it in the sense that I'm trying to help them deal with something that they probably regret very much, and that they would never do again if the circumstances presented themselves.
You know, you mentioned plea bargaining, and I don't see it in my stack, but somebody here tonight asked a question about what we thought about plea bargaining, because they don't have it here in Sweden. And that's, you know, it's kind of interesting to imagine a system without it, because it's been so long that we've had it in America. But it does have its benefits and problems. The benefit is in part to the system, because if every defendant has a right to a trial, a jury trial in America. And if every single defendant demanded that right and forced the state to do that, the system would completely collapse overnight, because they do not have the resources to do that. So it helps the system and it helps the state in that regard. It also helps the defendant if, in fact, it's a matter of getting a more reasonable sentence. But one of the problems, I think, that has resulted from, not just from plea bargaining, but from plea bargaining in conjunction with some other parts, changes in the law, is that we have a vanishing trial these days. There's an organization called fairtrials.org, based in Brussels and the UK, that's done a study about how just really in the last 20 years, how much fewer jury trials or court trials there are in every country. And you can look at this decline to the point where it's, in America, 95% of the cases now are resolved without a trial. Some cases maybe should be resolved. Maybe more cases should be resolved with a trial. But what's contributed to that, I think, is that the plethora of laws that allow prosecutors to charge so many different ways the same kind of conduct, and from very serious to death penalty cases to lesser ones. And the idea, I think, was that they want to give the prosecutor so many different ways to win that the defendant will be intimidated into giving up his right to a trial. And it works. And it works all too often. In America, there's another recent study that shows with misdemeanor cases in particular,
Which are the less serious cases.
Right, so anything with a punishment, potential punishment of 1 year in jail or less is considered a misdemeanor in America. And we also, most of the states have bail, cash bail requirements where you can be held in custody until your case gets resolved. And then oftentimes, people will be sitting in jail so long that it's like, if I want to go to trial in this case, I'm going to end up serving more time than I would if I just pled guilty. So give me a deal, I'll plead guilty, just get me out of here. And you know, that happens shockingly frequently in America. And that's another factor that's contributed to the decline in trials.
Yeah, you know, when I started, I'm not gonna say how long ago that was, but I was a public defender in federal court in the United States. And at that time, there really wasn't much, if any, plea bargaining in federal court. You got charged with pretty much what you did, and if you pled guilty, you knew that the judge would take that into account because you had accepted responsibility, and you would end up with a somewhat more lenient sentence than if you insisted on going to trial. But it wasn't really a plea bargain, it was just this, and I remember explaining to people, listen, I can't promise you that if you plead guilty, the judge is going to be more lenient, but that's my experience, that judges take that into account. And so in those circumstances, people, A, were willing to enter a guilty plea because they were pleading guilty more or less to what they had actually done, and the sentences weren't as completely ridiculous as they are now in the United States. I mean, they're just absurdly long. So they weren't that bad back then. And so people would plead guilty, and the judge would take that into account, and there'd be a reasonable sentence, and the person would serve his sentence or her sentence and get out. You know, now the sentences are so incredibly long, and prosecutors overcharge, grossly overcharge what the person's actually done, that the whole system is set up to encourage this sort of bargaining. And you're exactly right, it would break down without it. So you all are quite fortunate to not have to deal with that. And indeed, it was a lot easier as a lawyer not to have to deal with that. You know, to just be able to say to somebody, listen, if you plead guilty, you're going to be treated better, but it's your choice. And if you want to go to trial, we'll go to trial. Anyway, so there's a question about the Denny suspect theory in the Macon murder case, and I know that's something that's come up in season 2 as well. Can you talk a little bit about that and what that means? I know you alluded to it before. But
Sure. So it's a rule of evidence. As I said, most states have it, and it's premised on the idea that you shouldn't be able to, two things. Number one, that you shouldn't be able to accuse somebody of being, let's say, a murderer in court when that person's not on trial and can't defend themselves. A reputational kind of concern. But also that a jury shouldn't be distracted from the real task of looking at the evidence in this case if you're just trying to point willy-nilly at some other suspects. And so even though a defendant in America has a constitutional right to present a defense, the courts have ruled that that's not unlimited, and that they can impose reasonable restrictions on that, so that when it comes to what we call in my state Denny evidence, but it's really just the other person defense, a third party committed this crime, not me. You have to be able to show at least that there's a reasonable possibility that this other person could have. So if somebody is maybe there is a motive where somebody's a business partner who the victim ends up dead, and the business partner's going to take over the whole business, and therefore he had a reason to kill his partner, but he was in Hawaii at the time of the murder in New York. Then it's impossible. And so they came up with some rules that there has to be reasonable access and opportunity for the other person to have done the crime before you can start pointing the finger at them. And some kind of direct connection that person might have had to the crime. And now they've added the idea that I talked about earlier, which is this motive. It used to be you'd have to have either or, but now it's like you've got to have access and opportunity as well as motive and a direct connection to the crime. And it's gotten to the point where it's almost impossible. I have, since the Avery case, I have raised the third-party Denny motion a number of times and never won. Even in a case that was potentially stronger, a case of child pornography case, where the images are found on the defendant's laptop, but that other people have access to that laptop, including a person that I was able to show had underage pictures on his phone and it was seen using the defendant's laptop within days of the search warrant in this case. And the judge said that that wasn't enough to say that that person could have been the one who downloaded those images. So it's really become ridiculous when the state is the one that has the entire burden of proof to put these kinds of burdens on the defense before you can even point the finger at somebody else is, I just think, a real double standard.
But this new evidence about what was on Bobby Dassey's computer may change the calculus on that, yes?
It might, and frankly should, and I think in fact would have made a difference in that case if we had known about it. And right around the time that we were filing our motion to allow us to point the finger at Bobby Dassey as well as other people that we thought could have been suspects, the state had withheld this, their own forensic analyst who had looked at a computer in the Dassey home, a computer which it turns out had, according to their experts' analysis, downloaded really graphic torture pornography, murder pornography, decapitated heads, women around the same age as Teresa Halbach had been killed, and that these download times were times when only Bobby Dassey had access to the computer, because Brendan was at school, his mom was at work, no one else was around. And it's my belief that the state deliberately withheld that report from us because they knew that that would have strengthened our case to point the finger at him as a suspect, and he ended up being one of the state's key witnesses in the case. So if we had had that information when we filed that motion, so they withheld it not just from us, but from the judge, in essence. Making the judge rule on that without knowing that information, I think, was unfair and improper, and ultimately might be grounds for a new trial for him. All right, so there's a question here that what was your first impression, David, when you saw the staircase? And it wasn't clear to me whether they mean the documentary, The Staircase, or the actual staircase.
Well, let me answer both.
Yes.
Answer both, Mike.
I'll answer both. The documentary question is much easier and straightforward. My reaction, I watched The Staircase for the first time before it was ever aired on TV. I flew to Paris and I watched all 8 of the first episodes in a room by myself over 2 days, 4 episodes each day. And it was 2 of the most depressing days of my entire life. Seriously. I mean, it was just had to do it because the agreement I had with the filmmakers was that if there was anything that they had filmed that was confidential between Michael and myself, that if I wanted that to remain confidential, that they would honor that. And that was the only condition, that was one of the only conditions I would do this whole thing under. So as part of that, obviously, I needed to go to Paris and watch it. But you know, at that point, Michael was doing life in prison without parole. And you know, I'm watching this Germany evidence come in, and I'm watching this bisexuality evidence come in, and I'm watching Freda Black make her closing argument, and I'm watching Dwayne Deaver lying, and I'm watching the judge refusing to give me an answer about whether he's going to let it in time, you know, before the trial, and all the things that you know, you all saw in those first 8 episodes happened to me in real time, and now I'm sitting there watching it while my client's in prison doing life without parole. So it was really horrendous. Interestingly enough, I guess it's not really a surprise, when I went back and watched it in 2018, when the Netflix thing came out, I watched all the episodes again, including those first 8. And those first 8 didn't really bother me nearly as much, because I knew that at the end of the day, my client wasn't doing life without parole. Now, in terms of my reaction when I saw the staircase, it was sort of shit. You know, that's
a lot of blood.
Yeah, it's a lot of blood. And it's why I hired the experts I hired, because, you know, one of the things I love about what I do is that I get to learn about a lot of different things in each case, and I don't consider myself, you know, to be the expert on everything that comes along, and so when something like that presents itself, I want to consult with experts. I want to find out from people who really do this stuff, how could that happen? You know, because Michael told me right from the start that he had nothing to do with Kathleen's death. Everything he told me about that evening was corroborated by independent witnesses. Everything he told me about his relationship with Kathleen was corroborated by independent witnesses. It didn't make sense to me, based on what I knew, that they had gone from this domestic scene of watching this romantic comedy, drinking wine, to that horrendous, what the police claim was this horrendous murder in the space of a couple of hours, without any real substantial motive. But there was all that blood, and I knew that was going to be a problem. And so I contacted the people I contacted, and one of the first things I did was I brought Henry Lee and Tim Pombach and Werner Spitz and Faris Bandak, all these experts with different backgrounds and different areas of expertise to come to the scene, not to help me construct a defense. I mean, that's, you don't ask people of that caliber to come and make up stuff. What you do is you ask them to come and help explain to you what they see and how this could have happened and what are the potential explanations for this. And so that's what I did. It was a problem in the case. It became obviously much more of a problem with Dwayne Deaver and Jung Symes. And that's one of the things I hope we'll be able to talk about, because what Dwayne Deaver did in terms of his experiments was absurd in my view. It was the opposite of scientific method. Scientific method, you have a theory, and then you set out to disprove that theory. That's what your experiments should be designed to do, to disprove the theory you've come up with. And if you can't disprove it, and if other people who are qualified can't disprove it, and you then write an article about the theory and about the experiments you've done that haven't disproved it, and that article is peer-reviewed by other experts, and all of them agree that the experiments you did were valid, and if the theory was not valid, it would have been disproved, then maybe after that whole process, you have a theory that can be presented in court. What Dwayne Deaver did, as you all saw, was create experiments to try to recreate whatever it was that he wanted to say had happened. And even doing that, as you saw, and I've got a clip.
Why don't we go to this clip? Explain a little bit what this is.
Yeah, so I've got a couple of different clips here, but the first clip I'm going to play is me and several of my experts watching these experiments, watching some of the experiments that Dwayne Deaver did. You can see sort of what Dwayne Deaver is trying to do.
Let me see how much goes back.
Yeah, I see a fair amount along the base there.
They actually prove that you get a fair amount of spatter low down, and then of course there's a piece of skull that they pick up.
I'd love to hear the audio.
Do they have an audio for this?
He says, "Give me another sponge. Let's put the sponge down on the floor." Look. So they put the sponge down on the floor. Now let's beat it some more. Watch. 1, 2. Oh, broke. 3, 4, 5, 6, 7, 8, 9. And they still have the spiral away one.
So, think about it for a second. The prosecution's theory, as explained by Deborah Radish, was that, and Deaver for that matter, was that Michael Peterson had struck her in the head 5 times. All right? They take a sponge filled with blood, they lay it down on something that's 6 inches off the floor, which is where they claim that her head was when Michael was beating her, and all this blood was spattering up the walls. And they beat it not just 9 times. I mean, that's just one. I think there was something like 35 or 40 of these that were done. And they never get the spatter to match anything close to what's on the walls. And the reason for that is, what was on the walls wasn't caused by a beating. It wasn't even caused by a fall. It was caused by the fact that she was covered in blood from her head bleeding. Her hair was covered in blood. Her mouth was full of blood. And she was, thrashing around. And that's what got the blood all over the walls. And it wasn't, that blood, as Henry Lee said at one point, it was too much for either a beating or a fall. It came from other mechanisms. So, what Dwayne Deaver was trying to do didn't even work, because he couldn't recreate it, except he did get one little spatter inside. He held his shorts out and finally got a spatter inside the shorts. And then, if you remember, his assistant did this little victory dance after he finally accomplished that.
So, let me interrupt for a second. When I saw you watch that part of the clip, and you guys are in the office watching this and preparing for this, and, having fun and saying, can you believe, look what he's doing? It's like, I've been there, and I remember, when you look at some of this junk science that they present, and you think, how can this jury buy this? I mean, this is ridiculous. What reasonable jury, particularly anybody within the education level, is going to accept that? And yet, we know that shows like CSI and a lot of other American shows, they provide this false impression that crimes are always solvable by science, objectively, yes or no, guilty or not guilty. when in fact that isn't the case, and that a great deal of so-called science that's introduced in trials is fake science. It's not like Deaver, but even, I want you to show this next clip, somebody, another witness in your case, that's not actually in the documentary, right?
Yeah. Before I get to that, though, I think the reason why, and I watched that, and I'm sure many of you watched it and said, well, that's just ridiculous. I mean, it's a joke. And that's sort of how I viewed it. But yet, when he came into court with this sort of patina, this cloak of respectability because he's a State Bureau of Investigation, he's a law enforcement agent. And I think most jurors give great respect to law enforcement agents. He comes in and he uses a lot of big words, and maybe the jurors are not as educated as we would have liked. And then of course Freda Black, in her closing argument, criticizes us for bringing in all these high-paid experts from other places. You need to just believe good old Dwayne Deaver. He's one of us. He's tried and true. He's going to be in this courtroom, many, many times in the future. So if you're going to believe Henry Lee, then you've got to believe that Dwayne Deaver is a liar. Well, guess what? Dwayne Deaver was a liar. But, that's the argument that gets made. And jurors buy that. Now, let me play for you a clip that will, I think, convince you that there are experts in the world who are even more outrageous than Dwayne Deaver. So, let me set this up for you. Faris Bandak was our biomechanical engineering expert. He worked at the National Transportation Safety Board, which is a safety agency in the United States that studies car accidents. And his particular expertise was what causes head injuries in car accidents, and what degrees of force can cause various injuries, and what kind of padding do you need within the dashboard and the various other parts of the car to prevent serious head injuries. That's his area of expertise. The prosecution hired a man by the name of Sammy Shabani. And Sammy Shabani claimed to be a PhD in physics, claimed to have been a graduate of Oxford University in England. He spoke with this very, very eloquent British accent, which sounded like he knew everything in the world. And he claimed that he was a professor at a university in Philadelphia, Pennsylvania, in mechanical engineering. And his goal was to come in and convince the jury that